and check again. Is anyone having trouble hearing me or understanding me? Do you need me to take the mask off? All right, great. Once you have received the case and are deliberating, you're going to be asked guilty counts, meaning each juror must agree either to acquit or convict on each count. The burden of proof on the state is the same in the guilt phase of a capital case as it is for every other type of criminal case. It is proof beyond a reasonable doubt, and the instruction you will receive on reasonable doubt is identical to the one given in all other criminal cases. The burden on the state is not higher because of the potential penalty. When you're deciding guilt in this phase of the case, you will be instructed to ignore the possible sentence during this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including first-degree murder, on their own merit, and you will be told to disregard the possible consequences of your verdict. The only question you are to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as any other of the offenses charged, or guilty of a lesser included offense, or not guilty. We expect you, as jurors, to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. If and only if a jury returns a verdict of murder in the first degree, the jury will then reconvene for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. If that happens, there is a special set of rules and instructions that come into play. I'm not going to read all those to you right now. What I'm going to do is give you a broad overview of the penalty phase, all right? This second phase is known as the penalty phase. First phase is guilt phase, second phase is penalty phase. Because the death penalty is reserved in Florida for one class of crimes only, and that's murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The circumstances are known as aggravators and mitigators. The state relies on aggravators. Aggravators are reasons the state believes the verdict should be for death. They're limited in number by statute to 16, and the state is required to prove those beyond and to the exclusion of a reasonable doubt. The circumstances the defense relies upon are called mitigators. Mitigating circumstances do not need to be proved beyond a reasonable doubt. They need only be proved by the greater weight of the evidence. It's a lesser standard or burden than what the state has. Mitigating circumstances are not limited by statute and may include matters relevant to the defendant's background, character, or the circumstances surrounding the offense. They are offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. Life in prison without the possibility of parole means exactly that. The defendant will die in prison. The state of Florida does not have parole. Before you may vote the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt, and the vote for death must be unanimous. All jurors must agree to that vote. This penalty phase is another trial, in essence. The state goes first. They present evidence of aggravators. The defense then presents evidence of mitigators. As jurors, you are required to be able to keep an open mind, regardless of the fact that you've convicted someone of first-degree murder. You have to be able to keep an open mind at this stage of the proceedings. And by open mind, what we mean is you need to be able to listen to all of the evidence to the very end. You need to be able to process it and absorb it. It's not your job to sit in the jury box during the penalty phase thinking, sure, I'll listen, and then I'm going to vote the way I was going to vote anyway. That's not keeping an open mind, all right? So once you've received all of that evidence, I'm going to give you the jury instructions and the rules for dealing with this evidence. Again, the jury instructions are the law that needs to be followed in this case. You're then going to go back into the jury room to do what we call weighing the aggravators and the mitigators. This isn't a mechanical or mathematical process. You don't go back there and add up the number of aggravators, add up the number of mitigators, and say, oh, this side wins because they have more. That's not how it's done. This process is an individual process for each juror. Weighing aggravators and mitigators involves you as an individual determining what importance those factors have to your decision in this case. So you can give them what we call great weight, moderate weight, no weight. It's really up to each individual juror. And by that, I mean, you could be in that jury room saying, you know, I believe this aggravator is very important to my decision, but this one doesn't really matter to me. The juror next to you may be saying, well, the one you don't think is important is the one I think is important. The mitigators, same thing. You may find some to be critical to your decision. You may find others either not important at all or less important. It's really up to each one of you. You can discuss this as a group, all right? As a group, there is one thing that you have to do, which is this. Each juror must find at least one aggravating factor beyond a reasonable doubt before death becomes even a possible sentence. If all 12 jurors do not find that the state has proved at least one aggravating factor beyond a reasonable doubt, death is not a possible sentence. The sentence is life without parole. I know this is a lot of information. Again, relax. You're going to get all this in writing if you're on the jury and if you end up in a penalty phase. But anyway, once you've weighed all these aggravators and mitigators, it's then time to vote. Regardless of your findings in this respect, regardless of your vote, however, you are never compelled nor required to vote for a sentence of death. All right? And we'll go into that in more detail during questioning. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. Again, the vote for death must be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If, after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility for parole. Again, this is a very broad outline of the penalty phase. I also want to say this, which is, just because I'm talking about the death penalty, it's not to be taken by any of you as an indication, one way or another, as to whether or not this is a case that warrants a death penalty. I don't know that, and you don't know that. I'm only discussing this because it's a possibility, and we need to know, and you need to know, if you're able to do your job as a juror in this case, if you end up in a penalty phase. And your job is to follow the laws of the state of Florida and not violate your oath as a juror. We're going to be asking you questions about the death penalty. I'm going to tell you what some of them are so you can think about this. You may be asked what your position is on the death penalty, what your beliefs are about it. Can you go through the weighing process that I described with an open mind? Can you listen to the evidence on both sides? Are you someone who believes that if a person is convicted of first-degree murder, and first-degree murder is the premeditated killing of another human being, intentionally killing them, when you have no legal reason, no legal justification for it. For example, it's not self-defense, it's not anything, you just killed someone. Are you someone who believes that a conviction for first-degree murder should always result in a death sentence? As I've told you all before, the state of Florida does not have an automatic death sentence for any type of case. So we're going to ask you whether you can go through this process, whether you're comfortable with it, whether you have any personal beliefs that would make it impossible for you to follow the laws of the state. A lot of people have strong feelings about the death penalty, one way or another. That does not disqualify you from being a juror as long as you can put those feelings aside. Changing gears slightly, I want to talk to you all about the insanity defense. In this case, Mr. Loyd has raised the defense of insanity. There is a jury instruction on it. It's pretty lengthy, but the only thing I'm going to read to you for today's purposes is the definition of insanity. A person is considered to be insane when he had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. We are going to be asking you questions about this type of defense and your ability to listen to it with an open mind and accept it if it was proven. We'll tell you the insanity defense is raised in the guilt phase of the trial, the first part of the trial where you're trying to determine whether someone's guilty or not. It is the one time the burden is on the defense in the guilt phase. They must raise the defense and they must prove it. The standard is clear and convincing evidence, which is a lesser standard than the state standard of beyond a reasonable doubt. As I said, we'll have some questions for you about that. Lastly, I want to read to you a statement about the case. On the morning of January 19th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27th, 2019 and concluded on October 23rd, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. That last paragraph I read to you about Ms. Dixon and her unborn child, she was pregnant at the time, that information cannot be used by you in determining whether or not Mr. Loyd is guilty of the charges he faces in this case. They're two separate cases. That information is only relevant in the penalty phase. So we're going to be talking to you about your ability to process that information correctly and not use it in the guilt phase. All right, by show of paddles, folks, how many of you have heard about this case? Raise your paddles. All right, when I call your number, you can put your paddle down. 41, 42, 44, 45, 48, 50. From panel 10, 15, 16, 22, 24, 27, 30, 31, 32, 36. For those of you who raised your paddles, how many of you have formed an opinion about Mr. Loyd's guilt? Raise your paddles. 41, 44, 45. Let's see. You can put them down once I call your number. 22, 24, 27, 30, 31, 32, and 36. All right. Is there anyone on the jury who has a personal religious or moral belief that would prevent them from ever imposing a death sentence or voting for a death sentence regardless of what the law is in this case? All right. 41, all right, 38, 41, 44, 45, 48, 50, 22, 27. Is there anyone on the panel who, if someone is convicted of first-degree murder, believes that the sentence should be death? All right, I have 22, 30, 36, and 16. All right, ladies and gentlemen, thank you very much. What we're going to do is we're going to send most of you back into the jury room. Juror in seat 38, you can remain in the courtroom. The rest of you follow the deputies. Remember, don't talk about this case among yourselves while you're in the jury room, okay? Thank you. sir. Okay, 41 will be the next seat. Thanks, sure. Thank you. Good morning again. You feel like you're in the hot seat? All right. Because we're not using microphones for you all in this courtroom, you need to speak up, okay? All right, great. Perfect. Can you hear me okay? All right. I have a few questions for you. Then the attorneys may have some questions. There aren't any right or wrong answers to my questions or anyone's questions. The point of the questions is to find out whether or not you can do your job as a juror in these types of cases. You need to know that. We need to know that. So the only correct answer is the truth. You indicated that you have a personal, moral, or religious beliefs that would make it impossible for you to ever vote for the death sentence. Is that correct? Which one is it, ma'am? And you're from panel 9, right? Let me see. I'm talking to myself, sorry. You're juror number 11, right? Okay. So it's a moral. How long have you held that belief? Okay. So you heard me describe the process of, someone's been convicted. You voted guilty beyond a reasonable doubt of first-degree murder. Now you have to listen to the aggravators and the mitigators with an open mind. The time has come to vote. In your belief, the appropriate sentence is life. Can you vote for that? In your belief, the appropriate sentence, the evidence, the law, it's all led you to the appropriate sentence is death. Can you vote for that? So you can vote for a death sentence? Okay, so do you believe that you would be able to listen with an open mind to both sides? Do you have any doubt about your ability to do this? All right, let me move on very quickly to the insanity defense. You heard me describe that. Burdens on the defense, clear and convincing evidence. Pretend it's the end of the guilt phase. You've heard the evidence from the state, you've heard the evidence from the defense. If the defense convinced you he was insane at the time, would you be able to return a verdict of not guilty by reason of insanity? And then lastly, the murder of Miss Dixon and her unborn child. Is that something that you can put out of your mind when you're trying to decide guilt? Okay, because you can't use that to decide. You can't say, well, he was guilty of that one, he must be guilty of this one. You understand? Okay. Is there anything about the fact that the person who died was a police officer that if you convicted Mr. Loyd would cause you to automatically vote for death? Is there anything about the prior murder that would cause you to automatically vote for death? Thank you very much, ma'am. I appreciate your attention. The state attorneys are going to have some questions for you. Who's up? Mr. Williams, you may inquire.
Thank you, Your Honor. Good morning. So I'd like to ask you about the moral objection to the death penalty. Starting with, please don't be offended by this question, the moral aspect of it. Some people, then their moral beliefs are like the core of who they are and guide their decisions throughout their life. For other people, like, you have your moral beliefs, but they're, lack of a better word, flexible. Where would you put yourself in regards to those two possibilities? Are they guide everything you do, or is it more flexible? Flexible. So the judge alluded to it. I don't recall if she specifically said it, but the law in Florida will provide you a lot of guidance as to how to make the decision on what the appropriate penalty should be, if in fact Mr. Loyd is convicted. Part of that guidance is that it will tell you specifically that a sentence of death is never required. In other words, you go through this process and find that everything is proven, make determinations that are required to be made, that is to be voted for. You're authorized. Even that process, you have to be authorized. You can go outside, that's different than when you have to. So, given that it's never required, and that you could make all of these findings and believe that a sentence of death is appropriate, and then given your moral belief that the death penalty is not appropriate, could you still vote to impose a sentence of death on the next accused? It's like, it's one thing to tell us, like, I understand, yeah, the process. It's another thing, and I'm asking you to put yourself in that situation. Because once we get down the road, it's too late after 2 weeks of evidence, and you realize, I understand it's a hard thing I'm asking you. It is a hard thing, and it should be a hard thing. But what I'm interested in, while it's hard for everyone, when someone says they have a moral objection to the concept, then I think maybe it gets a little more difficult. Do you agree with that? So you're not sure you could do it. Even if you thought that it was the right thing, you're still not sure you could actually be a person who participate in that. I'm going to say it a different way, and if I say it wrong, tell me. Would you agree that you have a doubt about your ability to do that? That's all. Thank you. Thank you.
Mr. Lenneman, inquire.
Yes. So in the very beginning, when you were talking about life and death, it sounded to me like you were pretty convinced that you can do your job and consider it life and death. And it certainly is a hard decision, not only for you, but other jurors will have to make a decision. So the real question here is, I know the prosecutor said, I want you to put yourself in that position and think what you would do. And you said, I thought you said it would be difficult or hard. Yeah. Okay. The real question here is, can you follow the law? The law says that in order for you to sit on this jury, you have to be able to consider both life and death as a possibility. Can you do that? And it also says it has to be a real consideration. So it just can't be taught. So if you look deep down inside you, can you give it a real consideration, the death penalty, if you were put in that position? Thank you.
Is that it, Mr. Warren? All right, either side need to approach?
Yes, Your Honor.
All right, let me see the attorneys at the bench. All right, ma'am. We're going to send you through to one final round of questioning in this case. I don't know when it's going to be. It's going to be next week, early next week would be my best guess. So what we're going to do is, if you'll hand your badge to the deputy, we're going to change your color to purple. As I said, I call the jurors in by color. So you're going to be in the purple group. So now we're also going to give you a packet. The packet has a slip of paper in it that gives you a phone number to call to determine when you're supposed to come in. Call tomorrow. Wait until after 4, okay? If you hear purple group returning or purple dots returning, you'll know it's time to come back to the courthouse. That last day, that's the last round of questions. We are going to pick the jury that day, and we're going to sequester the jury that day. So you're going to need to have packed a suitcase. You can leave it in your car. If you need it, we'll have you get it if you're picked for the jury. If not, you can just go home. There's also a sequestration package in there. It tells you a little bit more about being sequestered, gives you a little bit more information. It also has some suggestions about what to pack. There are laundry facilities, so you don't have to pack 3 weeks worth of clothing. And there's a letter in there for your employer telling them we're calling you back one more time. Any questions, ma'am? Thank you so much. We will see you next week. Yes, ma'am. You're free to go for today. Thank you, you too, ma'am. Okay, seat 41, please. This is still panel 9. I want 41, hold on. And then I'm going to want 44. 44 will be next after 41. Morning, ma'am, have a seat. How are you this morning? Okay. I know this isn't the most comfortable or relaxing atmosphere, sitting in a chair all by yourself, everyone's looking at you. Try to relax as much as you can, all right? We're going to be asking you some questions. I'm going to go first, then the state and the defense. There aren't any right or wrong answers to these questions. The questions are designed to determine whether or not you can do your job as a juror in this type of case. You need to know that, and we need to know that. The only correct answer to a question is the truth, okay? So let me start by saying, you indicated you had a lot of information about this case, is that correct? All right, and that based on that, you had formed an opinion as to whether or not Mr. Loyd is guilty? And what is your opinion, ma'am? Okay. In order, as you heard me say, that in all criminal cases, jurors must be able to presume the defendant to be innocent until and if the state proves they're guilty. Can you do that in this case, or would you begin the trial believing Mr. Loyd to be guilty? All right. All right, so let me give you 3 scenarios. You tell me if any of these apply to you, and if none do, just say none, all right? Scenario number 1, it's the first day of the trial. You're sitting in the jury box. We haven't even started. You're mentally thinking, this man is innocent and the state needs to prove this to me. Scenario number 2, you're sitting in the jury box thinking, this man is probably guilty. However, I'm going to listen to the evidence and see if I'm right about that. Scenario number 3, you're sitting there thinking, this man is guilty, but if he can convince me otherwise, I'll vote not guilty. Which one of those applies, if any? The third? All right. Thank you, ma'am. State? Defense? All right, ma'am, you're free to go. Thank you very much. You're excused. You're in seat 44, and after that's going to be 45. Yes, ma'am. Have a seat, ma'am. Do you need to approach?
Just directing her date of birth.
I'm sorry?
Her date of birth.
Oh. Good morning, ma'am. How are you? All right. Before I get started on asking questions and explaining things to you, ma'am, based on your date of birth, you are entitled by law to be excused as a juror. Do you want me to excuse you as a juror? All right, thank you, ma'am. You're excused. Have a good day. Juror seat 45. Next up will be juror in seat from panel 10 will be juror 22. Good morning, how are you? I'm well, thank you. So I'm going to have some questions for you. There aren't any right or wrong answers to these questions. They're designed to determine whether you can do your job as a juror in this type of case. You need to know that, we need to know that. The only correct answer is the truth, okay? So you've heard about this case, is that correct? And based on that, you formed an opinion as to Mr. Loyd's guilt? Yes. And what is that opinion? All right, you have to, in any criminal case, you have to be able to presume the defendant innocent until and if the state proves him guilty. Can you do that in this case?
I could try to do it. I'm familiar with one of the officers that was actually murdered. Well, he got died during use a piece of software. I work at past filters, which is one of the liquor stores that use that.
Okay, so you have some personal feelings about this also. State?
Move on.
Defend? All right, sir, not the case for you, but thank you anyway. Have a good day. You're excused. Juror in seat 22, panel 10, followed by juror in seat 24, panel 10. I've switched panels for the next few minutes. Morning. Ma'am, are you juror number 129? Okay. I have a few questions for you. There are no right or wrong answers to these questions. The questions are designed to determine whether or not you can do your job as a juror in this case. So the only correct answer is the truth, okay? You said you'd heard about this case, correct? And that you'd formed an opinion as to whether or not Mr. Loyd is guilty based on that. Is that correct? What is your opinion? Okay. Is there anything, can you start the trial with an open mind, presuming him to be innocent? All right, thank you. Stay.
Agree.
Thank you, ma'am. You're free to go. Have a good day. 24 is next, followed by the juror in seat 27. Sir, you're juror number 677, correct? All right, good morning. I'm going to be asking you some questions. There aren't any right or wrong answers to these questions. They're designed to determine whether or not you can do your job as a juror in these cases. So the only correct answer is the truth. You indicated that you've heard about this case, is that correct? And that you formed an opinion of about Mr. Loyd's guilt based on that? Okay, well, what's your opinion? Okay, so you believe him to be guilty? You have to start trials with presuming a defendant to be innocent. Can you do that in this case, or would you start presuming him to be guilty? All right, thank you. State. All right, thank you, sir. You're excused. 27 will be followed by 30. Good morning. You're juror 886? All right, ma'am. A few questions for you. No right or wrong answers. We're just trying to find out if you can do your job as a juror. It's something we all need to know, including you. So the only correct answer to a question is the truth. You have heard about this case, correct? And as a result of that, you formed an opinion as to whether or not Mr. Loyd is guilty? And what is that opinion? All right. Can you presume, at the start of the trial, would you be able to presume him innocent, or would you start the trial believing him guilty? All right. State. Defense. All right, thank you, ma'am. You are free to go. Your next, so next up is 30, followed by 31 and 32. Good morning, sir. How are you? I can relate to that. So I have some questions for you. There aren't any right or wrong answers. We're trying to find out whether you can do your job as a juror in this case. So the only correct answer is the truth. Can you told me that you've heard about this case, correct? Yeah. And you formed an opinion as to Mr. Loyd's guilt? Yeah. What is that opinion? State. Defense. All right, thank you, sir. You're free to go. 31. Next up will be 32 and then 36. Are you juror number 736? All right. Good morning, ma'am. I have a few questions for you. There aren't any right or wrong answers to these questions. We need to know if you can do your job as a juror. That's why we're asking them. So the only correct answer to a question is the truth. You've heard about this case, is that right? And based on that, you formed an opinion as to Mr. Loyd's guilt? And what is that opinion, ma'am? Can you put that aside and presume him to be innocent? You don't know? All right, let me give you 3 scenarios. You've been picked as a juror. You're sitting in that jury box. You're waiting for the trial to start. You haven't heard anything. In your mind, you're thinking, yeah, I think this guy's probably guilty, but I'll see if they can prove it. Number 2 is, I think he's guilty, but if he can convince me otherwise, I'll vote not guilty. Number 3 is, I presume I think he's innocent and the state should prove it to me. Do any of those apply to you? Okay, thank you. State. Thank you, ma'am. You're free to go. Juror in seat 32. Morning, sir. You are juror 871? Yes. All right, sir. Few questions. Only correct answer to a question is the truth. All we're trying to find out is whether or not you can do your job as a juror in this case, all right? So you've heard about the case, correct? Correct. And you formed an opinion about whether or not Mr. Loyd's guilty? I did. And what is that opinion? Can you put that aside and presume him to be innocent? All right, thank you, sir. State. Free to go, thank you. Juror in seat 36. And that's juror 634, and he's going to be followed by going back to panel 9, the juror in seat 41. All right. Next up will be panel 9, juror seat 41. All right, sir, you are juror number 634. Good morning. I'm going to be asking you some questions. There aren't any right or wrong answers to these questions. There's just a truthful answer. All we're trying to find out is whether you can do your job as a juror in this case. Okay. You've heard about the case, is that correct? And as a result of that, did you form an opinion as to Mr. Loyd's guilt? And what is that? All right. You're required to presume him innocent until the state can prove he's guilty. Can you do that, or are you just going to start out presuming he's guilty? Okay. Thank you. State. Thank you, sir. You are free to go. Thanks. So back to panel number 9. These are jurors who have issues with the death penalty. What? Oh, I'm sorry. So 44's already been struck. 45's been struck. So 48 and 50. All right. I can't keep up with my own notes. Good morning, ma'am. How are you? Can't complain. Thank you. So we're going to be asking you some questions. I'll go first, then the attorneys. I know this isn't the most relaxing situation, but try to relax. The point of the questions is to determine whether or not you can do your job as a juror in this type of case. You need to know it, we need to know it. The only correct answer to a question is the truth, okay? Let me start with the death penalty. You indicated that you had a religious, moral, or personal conviction that would prevent you from imposing death in any case. Is that correct? Which one is it? Is it religious, moral, or personal? Okay, how long have you held that belief? Okay. All right. So let me ask you this. You heard me describe what the process is. First, someone has to have been convicted of first-degree murder beyond a reasonable doubt. Now there's a penalty phase. You're the only person who knows the answer to these questions, all right? So you're sitting in the jury box. The penalty phase is starting. The law says you have to be able to listen to both sides, the state and the defense, the aggravators and the mitigators, with an open mind. You have to be able to process those, give them whatever weight you believe is warranted. And then it comes the time to vote. If everything you'd heard, including the aggravators and mitigators and the weighing of those, led you to believe that life without parole was an appropriate sentence, could you vote for that? And if it led you to believe that death was the appropriate sentence, could you vote for that one? Okay, thanks. State? Defense? All right, go ahead.
So you said that you never really gave it any thought. But throughout your life, you never had this firm conviction when you talk about death. Do you think that it's anybody who's having any conviction? Okay, what do you do? Okay. So here's basically the law. The only way that you can sit not considered. You have to do new. Some people can do that, and some people can't. And so this meaningful consideration is really about being able to follow the law. Because in this state, you know that and there are rules that you don't follow in for the living in regard to I know you have the Sade brothers, and you've been thinking about it a lot. So my question is that can you put that heavy burden aside and give true consideration to both life and death? Because you're never required to. The law says you're never required to. But you have to give it real consideration. You can't give it real consideration to your beliefs, then you can't come here. If you can give it real consideration in spite of your beliefs, if that's what the law requires you to do, you need to go on. Tell me what you thought about it. Okay, thank you.
All right. Thank you, ma'am. You're free to go. The Thanks. The next one up is the juror in seat 50. Following that juror will be the juror in seat 16 from panel 10. Come on in, sir. Have a seat in that chair. All right. Good morning. How are you? I'm doing well, thank you. Sir, I'm going to be asking you some questions. The attorneys may have some for you. There aren't any right or wrong answers to these questions. They're designed for all of us, including you, to figure out whether or not you could do your job as a juror in this type of case. So the only correct answer to a question is the truth. You indicated that you have a religious, moral, or personal objection to the death penalty. Is that correct? Can you tell me which one it is, or is it all of them? Okay. So is that belief, how long have you had that belief? Okay. And is that belief so strong that regardless of what the law, the evidence, the facts were, you would never be able to vote for death? All right, thank you, sir. State. Defense. Thank you, sir. You are free to go. All right, the next set of jurors has the opposite response. Death is an automatic sentence. So this is juror in seat 16. Oh, I'm sorry, this is panel 9, yeah. Or panel 10. Yeah. This lady's in panel 10. Good morning. We have a lot of jurors. We're just trying to make sure we have the right one. You are juror number 816, is that correct? All right. Ma'am, when I asked, is there anyone who believes that first-degree murder should always be sentenced to death, you raised your paddle. Okay. Tell me about that. Okay. All right, so let me ask you a couple of specific questions. Number one, obviously there's been a conviction for first-degree murder, all right? So you're saying that for you is enough to vote for death without hearing anything else. If I add that the person who died was a law enforcement officer, would that change your answer or make it more set in your answer? Okay, and if I add that there was a prior conviction for murder, would that make you more set in your answer? All right, state. Defense.
Agreed.
All right, thank you, ma'am. You're free to go. So up next is 22. Following that will be 30. Following that will be 36. Can't be 22 because I already struck 22. Yeah, never mind. And 30's gone too? All right, 36 then. 36 gone too. Well, there you go. So back to panel number 9. And this is regular individual voir dire. Juror in seat 39, followed by the juror in seat 42. morning. How are you? I'm doing well, ma'am. I realize this may not be the most comfortable situation you've ever been in, but try and relax. I'm going to be asking you some questions, and then the juror or the attorneys are going to ask you some questions. There aren't any right or wrong answers to these questions. The reason we're asking them is so that all of us, including you, can determine whether or not you could do your job as a juror in this type of case. So the only correct answer to a question is the truth, all right? So you've never heard about this case, is that correct? Or you have? No, you have not heard about the case. Let me take this off. Have you ever heard anything about this case? Okay. And have you ever thought about the death penalty? No? Not something that's ever come up? Do you have any beliefs about it? No? All right. So you don't have any religious, personal, or moral beliefs against the death penalty? You don't vote for it? You don't practice your religion? Okay. All right. So are you someone who believes that if a person is convicted of first-degree murder, they should automatically be sentenced to death? Are you having trouble understanding me? Okay. How much English do you understand? Right. Okay. Do you feel comfortable sitting as a juror? Do you think you understand everything we're saying, right? Okay. All right. And
because I want to be, I know, I understand what you do, and I want to be alive, and I'm kind of scared, maybe I will misunderstand something.
okay. Would you prefer to be excused as a juror in this case? Excused meaning, would you prefer not to be part of the jury in this case? You want to be on the jury?
I want to be just what I say. I'm scared. I can understand everything.
Okay. Well, let me keep talking to you and let's see if you can understand me, all right? You get nervous, yeah. All right. Take a deep breath, all right? None of us, I mean, no one's going to yell at you. This isn't a test. You know, we're just having a conversation. Yes, sir. Sure. Thanks. Ma'am, what we were talking about is the jury instructions in these cases. The jury instructions in these cases are complicated. They use a lot of big words and they're very complicated. You are a lovely person and we would love to have you on this jury, but I'm a little concerned that you're not, like you said, you're not going to be able to understand those. Yeah.
been doing so for our state.
Yeah,
He's guilty, how he's guilty. He's not just that he's not guilty.
right.
I say,
Yeah.
at least if I'm talking about this kind of my fault.
You know, you're exactly who we want on these type of juries, but this case in particular, it's so complicated that I'm a little concerned that you're not, I share your fear that you're not going to understand. So I'm going to excuse you from this jury, and I hope you get on a jury soon, because you're exactly what we need on juries. Yes, ma'am. Okay. Oh, I'm so sorry, but you have a good day, and I'm sure you'll get on a jury soon. All right, thank you so much, ma'am. Thank you, ma'am. You too. Who did I call next? 42? Yeah, 42. If that's what I said, yes. Yes, 54 and 56 are on deck next. All right. Good morning, how are you? Hanging in there. You're juror 879? Okay. Can you understand me with this mask on? Okay. So we're going to have some questions for you. There aren't any right or wrong answers to the questions. The reason we're asking is so that all of us, including you, can determine whether or not you could do your job as a juror in this type of case, all right? So the only correct answer to these questions is the truth. Let me start by confirming that you've never heard anything about this case other than what I've told you. Is that correct? Okay. The name just sort of connected to something, or just you kind of remember hearing the name? Okay. Do you have any beliefs about the death penalty? Okay. So let me go into that in a little bit more detail with you. In order to even get to a penalty phase, as I told you, a jury has to have convicted someone of first-degree murder, intentionally killing another person without any legal justification for it. You know, it's not self-defense, you have no reason, you just killed someone. And you found them guilty beyond a reasonable doubt. You with me so far? Right. Is that fact alone enough for you to say this person deserves the death penalty? All right. If I add to that the fact that the person who died is a law enforcement officer, is that enough for you to say this person deserves the death penalty, hearing nothing else? And if I add a last fact of there's a prior conviction for the murder of a pregnant woman, is that enough for you? All right. You heard me describe the process. Listen to the evidence, listen to the aggravators and mitigators, weigh those aggravators and mitigators, then you have to vote. If all that process led you personally to believe that life without parole was the appropriate sentence, could you vote for that? And if it led you to believe that death was the appropriate sentence, could you vote for that? All right. Switching gears to the insanity defense. As I explained, Mr. Loyd has raised that defense. It's their burden, being the defense's burden, to prove it by clear and convincing evidence. It's a lower standard. Pretend it's the end of the guilt phase. You've heard all the evidence. You're convinced that Mr. Loyd was insane at the time that this offense occurred. Would you be able to return a verdict of not guilty by reason of insanity? All right. And then lastly, the murder of Miss Dixon and her unborn child. You cannot use that to determine whether or not he's guilty of these charges. Two separate cases. Can you follow that instruction? Okay. You can use it in the penalty phase, but you cannot use it in the guilt phase. And are you comfortable you can follow that instruction? All right. Thank you, ma'am. I don't have any other questions for you. State, you may inquire. Mr. Williams?
Thank you. Good morning. So what day were you here initially? Last Friday. I apologize. We've been here a lot of days and they start to run together. So you had the weekend and then some to think about this. Did you take that opportunity, even if just for a few minutes driving home or whatever? You did. Can you tell me what you thought when you were considering the idea that you could be on a jury where death penalty was an option? What do you mean, how it would affect your life moving forward? Yes, ma'am. So I take it from your responses that you considered how it might affect you, and you're at peace with the idea that you could handle it whatever it is. The general question I'd like to ask is, on a scale of 1 to 10, with 1 being you really don't want to be here, and 10 being you're excited about the prospect since you've considered it, where are you on that scale as to your desire to participate as a juror? Do you, maybe you've never thought about it, but do you think that the death penalty is fair? That's a different question that you've been asked. Okay? Okay. So you mentioned that a few earlier when you were speaking to the judge. I forget the way you phrased it, but it was something to the effect of you understand the argument behind it or why it exists. Does that sound familiar? Which is more of a logical thing. And you just mentioned logic again. I want to flip to the opposite side of that, which is emotion. I'm sure you can appreciate that there will be portions of the evidence that most people would find to be emotional. My question is, do you have an emotional thought about the death penalty? Can you tell me about that? And my next question was going to be, which part of that do you think you would use to make your decision? But you've already answered that, so okay. The key part to the process, I'm not going to repeat it, because you've given a lot of thought to this, I can see, is that you be willing to meaningfully consider both potential sentences, again, if Mr. Loyd is convicted of first-degree murder, and not only consider the sentences, but the evidence. So we would present evidence of aggravating factors, and then the defense would have the opportunity to present evidence of mitigating circumstances. And those are specifically things about Mr. Loyd's life, background, and character. Even if you don't, well, I think you understand, but I want to make sure. Do you understand that it's your decision as to how much importance or weight to give to that? All right. Don't think I'm talking down to you. I just want to make sure that you understand. There are lawyers that don't understand this process. So, regardless of how important you thought any one piece of evidence was, you'd have to meaningfully consider it, even if it's something that's foreign to you. Do you think you could do that with any piece of mitigation that were to be presented to you before making a decision? I want to switch topics, and I probably should have talked about this first, to the not guilty by reason of insanity defense. Because insanity has been raised as a defense, I need to ask you a somewhat personal question, which is, have you or any member of your family or someone close to you dealt with mental illness in any way? Okay, so you have. Did those people or did that person seek treatment? So have you observed her in sort of bad states? That was my question. Okay. So I'm assuming that means that you believe mental illness is real and you could fairly evaluate that difference. Yes, ma'am. Last question. Is there anything else in your life experiences or background that you think we should know about you, given that we're trying to select the most fair and impartial jury for Mr. Loyd's case? By way of example, sometimes people say, my loved one was killed several years ago, or I studied the death penalty in school, something like that. Okay, that's fine. Thank you very much, ma'am. Thank you, Your Honor.
May I inquire?
So apparently you've done a lot of thought as a thoughtful person, understanding your responsibility. Before you got involved in this case, where did you fall? Always. So the law says that you can serve because you consider the aggravator. You couldn't consider the aggravator. So you gave us information. Part of the law is that although you have to consider the aggravating factors, even if you find that the aggravating factors outweigh the mitigating factors, you are never required to under any circumstance. So it's your instruction, that's the law. If you have some other reason that you don't want to vote for death, and you don't even have to have a law, I don't want to vote for death in this case, you can do that, even if the aggravators are eliminated. You can do that. And so, would you consider yourself a person that would, if you have a firm conviction in something, that would allow someone else to change that conviction? Okay, so here's the deal. The first part of the case is different than the second. So the second part of the case makes it absolutely clear that you are the decision maker on the body. It's an individual decision. You'll be told it's an individual decision. And that's what the law is. There are some people who bully other people, try to get them to change their opinion. So my question, I don't think I made it clear, is if you have a firm conviction one way or the other, and that's your individual decision, would you allow anybody to change? And you described it perfectly. In the second part of the case, it's not a group decision. You can talk about it all you want, or you don't have to talk about it. It's an individual decision. So at the end of the deliberations, they will tally a vote. 12 jurors vote for death, and that's death sentence. One juror votes for life, that's the life sentence. You need to have a unanimous decision. So if you're one person who the appropriate sentence. You're not going to let the other 11 try to. Thank you.
Either side need to approach? Nope. All right.
We not.
Hold up on the next juror. I'll need to talk to you for just 1 second.
No further questions.
I'm sorry, give me the seat number again. I lost her. Seat 42. All right, ma'am. We're going to send you through to the final round of questioning in this case. It's going to be early next week, but I don't have the exact date yet. So we're changing your color to purple because the last group is purple. And we're giving you a packet. Packet has a few things in it. Number one, a slip of paper with a phone number for you to call. Call tomorrow after 4, and you should hear what date and time you're going to report back. The day you report back, we are choosing the jury and we are sequestering the jury. So you will need to have packed a suitcase. Leave it in your car, all right? If you get picked, we'll make arrangements for you to pick it up, obviously. It also has in there a sequestration package that explains what it's like being sequestered, kind of gives you a little bit of the rules, a little bit more information about it, and some suggestions on what to pack. There are laundry facilities. You don't have to pack 3 weeks worth of clothing. And lastly, we have a letter for your employer or your school letting them know that you're coming back for another round. Do you have any questions? Thank you very much. Enjoy the beautiful day. We'll see you next week. All right, next up is juror in seat 54. Good morning, how are you? All right, we're going to have some questions for you today. Excuse me, I have to take notes and talk at the same time. Sometimes I'm better at it than others. So we're going to be asking you some questions today. There aren't any right or wrong answers to these questions. We're trying to find out, in asking you these questions, we're trying to determine whether you can do your job. Based on your head, I thought you could hear me better without the mask. Is that correct? All right. We're trying to find out if you can do your job as a juror in this case. That's why we're asking you these questions. So the only correct answer to them is the truth, okay? So let me start with, I don't have any notes indicating that you know anything about this case other than what I've told you. Is that correct?
Correct.
All right. Do you have a position on the death penalty? Okay. All right, so can I correctly classify you as someone who is neither for nor against the death penalty? All right. So you heard me describe the process. The first thing that has to happen is a jury has to convict someone of first-degree murder beyond a reasonable doubt. And first-degree murder is intentionally killing another person having no legal reason to have done so. You just killed them. Is that fact enough? Is that fact alone enough for you to vote for death? Okay. So let me add to that the fact that the person who died was a law enforcement officer, a police officer. Would that change your answer in any way? It could?
what I think, what I've seen on TV.
All right, so it's something that you would factor in, but not necessarily automatically say death. And then let me add one more fact. The fact that there is a prior conviction for murdering a pregnant person, would that change your answer?
I don't know that it would. I would have to look at the law.
Okay. So it'd be one of the things you would consider, but you wouldn't automatically vote for death. All right.
In the healthcare field, I'm a nurse practitioner. I was in the science and
That's the law in the state of Florida, okay? You heard me describe the procedure. You have to keep an open mind, listen to the aggravators, the mitigators. Do you have any concerns about your ability to do that? Any concerns about your ability to weigh the aggravators and the mitigators and follow the court's instructions? And if that led you to believe that life without parole was the appropriate sentence, could you vote for that? And if it led you to believe that death was the appropriate sentence, could you vote for that? Let me switch gears on you. The insanity defense, Mr. Loyd has raised it. Burdens on the defense to raise it and prove it. Pretend you're at the end of the guilt phase. Their standard is clear and convincing evidence, but you've heard all the evidence, the states and the defenses. You're convinced Mr. Loyd was insane at the time. Would you be able to return a verdict of not guilty by reason of insanity? Right. So I'm basically telling you, just pretend, you're pretending at this point that he's convinced you and that I've given you the law, and the law gives you the ability to vote not guilty by reason of insanity. Could you do that? All right. And then lastly, the murder of Ms. Dixon and her unborn child, you can't use that to determine whether he's guilty of these charges. They're two separate cases. You can use it in penalty phase, but not now, not in guilt. Do you understand that? Do you have any doubts about your ability to put that out of your mind in the guilt phase of the trial? All right. Thank you, sir. I don't have any other questions for you. Mr. Williams, you may inquire. The attorneys do. Go ahead.
Thank you, Your Honor. Good morning, sir. So let's start in chronological order with the way the trial would go, which would be, as far as what we're going to discuss here, your evaluation of an insanity defense. Because that defense has been raised and is an issue, I need to ask you if either you or anyone close to you have ever dealt with the issue of mental illness.
Consider myself a gentleman.
How long have you worked in that role? For your prior employment in this service, was it a similar type of work or was it entirely different? I gathered that from what I was reading, but it wasn't clear, so thank you for raising that. I did want to ask, there are particularly people work at a higher level in healthcare. I believe it's the Hippocratic Oath that doctors take. I don't know if nurse practitioners take it or not, but I think you'll see what I'm getting at here. If you take an oath to do no harm, and then there's a potential for conflict if you're asked to be involved in a process that could end up resulting in a person's death. Maybe you didn't think of it that way, and maybe that's not a problem, but I wanted to ask.
Wouldn't that be a problem?
And so you can separate those two things if there would be an issue. Okay. On a scale of 1 to 10, with 1 being you really don't want to be involved in this trial, and 10 being be very exciting to be a member of the jury, where would you fall as to your desire to participate in this process? What is that something that you feel you have to offer? Could you tell me a little bit more about, I'll start the question this way. When you filled out your questionnaire, there's a question on there about law enforcement, and if you're close to law enforcement or related to anybody, you said yes. Who is it that you're related to? You did. The question was, are you a close friend or related to a law enforcement officer? Okay. And the reason I asked about it was because the judge was asking you some initial questions about law enforcement, and would the fact that the victim in this case is a law enforcement officer impact, I forget the exact way she phrased it, but yes, and so most importantly, even if that ended up being significant to you, would that lead you to automatically vote to impose a sentence of death? The only other question I have is there anything in your life or background experience which you've actually kind of detailed for us that you haven't told us about that you think we should know about you, given that we're trying to select the most fair and impartial jury in this case? And by way of example, sometimes people say, I had a loved one who was killed many years ago, and that changed my life and my outlook. Anything like that that you think we should be aware of? 1 second. That's all I have. Thank you, sir.
Thank you, Mr. Williams. Mr. Linneman, you may inquire.
I can do, sir. So, talked a lot about this productive music, constant thinking, following the how would these factors
Going on.
You said you were, these are federal prisons where people are how does that really play into your thinking with all the knowledge you have about it?
I would look at that for seriously.
Objection to the relevance of that.
Hold on, sir, hold on. Objection sustained, let's move on.
So now, before your decision in the first part of this case, you're going to be presented with no review. So, when you say it has no bearing, you said, in the first part of the case, you're going to obviously So the next thing I want to ask you, I think you made it clear that you do not automatically. Correct.
Well, I have to, something of that sort, that apply, you know, what the criteria of the word, because a lot of it will turn out.
That's a good frame. So the framework is this. The only time you're going to be deciding phase one, I think you can do well. That is, you discover and you use that police officer. And, you know, you respond to that police officer that you automatically go to the next.
Objection.
Sustained.
You not automatically. You go.
This is, I think, in general, there is all of us are, even a lot of people, not like
So my question really is, who's going to do your own information and hear the interpretation of why Second, is you're in the jury room and they start looking at the jury basically saying it's supposed to or it's not. Are you going to answer questions, allow yourself to be information and deliberation about things you personally have training in
Objection.
Hold on.
Objection as to deliberating process of jurors and how they go about doing the process.
Sustained.
So let's talk about that. It's not a collective. You can talk about whatever you want, but it's a personal individual decision.
Excuse me, hold on. That is correct. All 12 people must vote for death for the court to be able to impose it. And if it's not a unanimous verdict, it's a life verdict. Go ahead.
I understand what you're saying. What I do understand is
You don't have a problem doing it. Now, being there, you allow, you have a firm conviction. If you allow jurors to go to you saw that building going on. If you allow that to happen. So, as soon as you read
Thank you. Either side need to approach? All right.
There you go.
All right, thank you, sir. We're going to send you through, wait a minute. Let me do this. Hold on. We're going to send you, if you'll give the deputy your badge. We're going to send you through to the final round of questioning in this case. We will be picking the jury from this group. You're now going to be a purple dot. It's just, last group is purple. It will be early next week, but I can't give you the exact date today because I haven't gotten to the correct number of people. We're giving you a package. In there, there's a slip of paper with a phone number for you to call. Call tomorrow after 4, and you'll hear the date and time you're supposed to report back. There's also a sequestration package that explains to you what it's like being sequestered, kind of what the rules are, and makes suggestions for what to pack. There are laundry facilities, so you don't need to pack for 3 weeks. No, there's a last round of, in there. This last round, we are going to pick the jury, and we're going to sequester the jury that day. So when you come back to the courthouse, you need to have packed. Just leave your suitcase in your car. because if you don't need it, we don't need it in the courthouse. So there's also a letter for your employer telling them that you've been ordered to return one more time for jury selection. Do you have any other questions? No, ma'am. Thank you so much. Enjoy the day. We'll see you next week. This is the juror in seat 56 and the final juror from panel 9 for today. Good morning. How are you? I know this is an uncomfortable situation for you. I mean, you know, you're sitting in a chair, we're all looking at you, but try and relax, okay? I'm going to be asking you some questions, and the attorneys are going to ask you some questions. There aren't any right or wrong answers to the questions that we ask. They're designed to determine whether or not you can do your job as a juror in this type of case. It's something we all need to know, including you. So all you need to do is tell us the truth. That is the only correct answer to any question that we asked you, okay? So to confirm, you've heard nothing about this case, is that correct, prior to what I told you? All right. Do you have any personal opinions about the death penalty? Okay. All right, so let me ask you some more specific questions. As I told you, the only way that you're even discussing a death penalty, a potential death penalty, is if someone's been convicted of first-degree murder. Intentionally killing another person, you have no legal reason to do it, it's not self-defense, you just killed someone, and the jury has found that person guilty beyond a reasonable doubt. You with me so far? Is that fact alone, with no other information, enough for you to say, I'm voting death for that person? If I add to it that the person that was killed was a law enforcement officer, does that change your answer? And if I add to it that there was a prior conviction for the murder of a pregnant woman, does that change your answer? Right. Right. And that is the correct answer to that question, which is this. I'll take the mystery out of it for you. Yes, it can be considered an aggravator if it's proven and you have the evidence of it. But what I'm trying to get at is, are you someone who, just because you convicted someone of first-degree murder, you're not going to be listening during the penalty phase, listening to the aggravators, listening to the mitigators with an open mind, able to process and weigh that information? Do you believe you could do that? Okay. Without making a decision until you've heard everything in the case, all of the aggravators, all of the mitigators? Can you do that? All right. And you heard me describe weighing aggravators, weighing mitigators, and what that process involves. If at the end of all of that, you've heard the evidence in guilt, you've heard the evidence in penalty, you've weighed everything out, you personally believed that life without parole was the appropriate sentence, could you vote for that? Yes, ma'am. All right. And if you personally believed that death was the correct sentence, would you vote for that one? Yes, ma'am. All right. The insanity defense, as I told you, Mr. Loyd's raised it. The defense has to raise it and prove it by clear and convincing evidence, lower standard. Pretend that it's the end of the guilt phase. You've heard all the evidence and you're convinced by the insanity defense. Would you be able to return a verdict of not guilty by reason of insanity? And lastly, can you put the murder of Ms. Dixon and her unborn child out of your mind when you're trying to decide about guilt in this case? All right. You're right. In penalty phase, you can, but in guilt, they're two separate cases. You can't use it for anything. You got it? All right. Thank you, ma'am. I'm going to turn this over to the lawyers. Ms. Williams, you may.
Thank you, Your Honor. Good morning. So, because insanity is a defense or possible defense in this case, I need to ask you, which is my way of saying I wouldn't normally ask this personal question, but for that, if you or anyone close to you have ever dealt with mental illness? Okay. Anyone close to you, aside yourself? Do you seek ongoing treatment? Well, the reason I ask that question is because there are those in our community and society who think that mental illness is not real. And more specifically, that mental illness is used as an excuse to justify certain behaviors. Do you feel that way? No. All right. So, given your experience and your answer, could you fairly listen to evidence about Mr. Loyd's mental state at the time of the offense, and if it were proven to you, could you find him not guilty by reason of insanity? Yes, ma'am. That was the first part of my question, but you feel free to repeat it back to me because I can tell that's how you like to learn. It's fine. It's absolutely fine. I do it, but in my head, and then people look at me funny, so it's fine. If you want to do it outside, it's absolutely fine. My perception is that you like to know what the process and rules are. So I'm going to go through it with you a little bit, because what I heard you say was that I wrote it down, I don't want to get it wrong. Reserved for the harshest crimes, necessary in some situations. As far as the death penalty? So, as the judge alluded to, as bad as committing a murder is, just doing that under Florida law is not sufficient to warrant a sentence of death or to even authorize it. What has to happen and what will happen if Mr. Loyd is convicted of first-degree murder is that we will present evidence of aggravating factors as the judge discussed. And she's already told you that a prior violent felony is an aggravator in Florida. And if and only if you as the jurors unanimously found that we had proven at least one of those aggravating factors, then you would move on to the second step of this process. And the second step is to weigh the aggravating factors, how important you believe they are, against the mitigating circumstances that are proven to you. Mitigating circumstances or anything about the defendant's life, background, or experience that the defense will argue is a reason why life without the possibility of parole is appropriate. Follow me so far? If you believe that the aggravating factors outweigh the mitigating circumstances, at that point you would be authorized to impose a sentence or to vote to impose a sentence of death. I use that word authorized specifically because you're never required. Right? The law that you'll receive from the court will be that a sentence of death is never required, and a juror can vote for life for any reason he or she believes is appropriate. Okay? So in other words, even if all the things are proven and found, and you agree that they're proven and found, you're not required, but you're authorized. That is the process. Anything about that process that you think you could not participate in or that would prevent you from being a fair and impartial juror in this case? The key part of what I just described to you is a juror's willingness to meaningfully consider everything they hear before reaching a decision. I think you'd have any problem doing that. Is there anything in your... Well, did you say you manage a team of people? Did I hear you say that? How long, well, where did you move from? It says Orange County for 2 years? Okay, very different location, which is possibly why you wouldn't have any information about this particular case. fair enough. Was it work that brought you here? Something else. Okay. Is there anything in your life or background experiences that you think we should know about you that we haven't discussed that would prevent you from being fair and impartial, or just since we're trying to pick the most fair and impartial jury for this case? If there was, you'd probably think of it, so that's fine. I don't have any other questions. Thank you.
Thank you, Mr. Williams. Mr. Lenneman, you may inquire.
Thank you, Judge. How are you? You've heard how this isn't easy. Completely up to you. You do the weighing of the aggravators, the mitigators, the decision whether or not. And in the middle of that is this big square that you never required of. Very simple. And you said you could do it. You can follow that law. So I want to talk a little bit about mitigation. Okay? The judge will instruct you in mitigation. Essentially, we are allowed to disagree. There are things like Mr. Loyd suffering the effects of racism. Let's say you presented
Objection.
Sustain. Ma'am, you don't need to answer the question. Thank you.
Tell me more about what
Objection.
Sustained.
you consider equal outcome.
Let me intervene here, Mr. Lenneman. Ma'am, let me explain something to you about mitigation, okay? Mitigation is reasons for jurors to believe that life without the possibility of parole is the appropriate sentence in a case. That's why it's being offered to you, all right? It can be anything that has to do with the defendant's background, defendant's character, the circumstances of the case. So it can be more than just the circumstances of the case. Do you understand that? It's broader than just the circumstances of the case. It can include background, character, those types of things. Are you clear on what mitigation, well, as clear as you can be, having not gotten the instructions on what mitigation can be and is being offered for? All right, thank you. You may proceed, Mr. Lim.
And when the judge was explaining to you that
Previous convictions for murder can be considered as an aggravator if proven.
So what we're really talking about, before you get to the penalty, you have to look at the decision that you first have to consider the not. Well, that's a separate thing. What we're talking about right now is a separate thing. So there was some hesitation with you when you told that Gibson defendant. My question is, do you have any doubt that you will be able to put that top during the first one?
Aggravator.
Okay, so I want to do the same thing for law. You know what you need to do. And you can use that in the second one. The integrity of one person and the law enforcement. But you have to do the first. Do you believe that this is important? I want to make sure I understand this. Can you explain to me that anything that you can do is okay? And my question to you is actually two questions I asked you. Do you consider basically something that is required, even though it's not necessarily entitled to murder, do you consider that as a duty? Examine mental health, as you said before, you can do that. Because you have to be tied into was your understanding initially, your son, was that directed to your own desires, or was it directed to your understanding of the law? And so the judge spoke a little bit about prosecution. In the second part of the case, you were told and you were told that you were I know you guys talk about it, discuss it, and come up with conclusions. Bottom line is, you make that decision, you understand that to do that, you would have to go through the steps. The first step is you as a group, and this is one time you as a group have to find a person one time. And that's going on all about you. You get to decide what the languages are, and then what the languages are. You get to decide what the languages are, and then what the languages are. And then you get to way two, which is yourself. And if you find that the mitigation that way is the aggravation, it's all in that. The aggravation of the mitigation, you may, is not required. You must follow it, and that is not. Decision you can make and whatever reason you make. And so at the end of that, then the decision, whatever you make, will be agreed with everybody else. If there is one vote without life, then that's not good. It takes all 12 votes.
Either side need to approach.
No, Your Honor.
All right. All right, ma'am, we're going to send you through to the final round of questioning. That's the day we're going to pick the jury. Deputy got your badge. We're going to change your dot from an orange to a purple. Purple is the last group. So I told you there's too many of you for us to call numbers, so we just call colors. Tomorrow, we're going to give you a packet. It's got a slip of paper in there with a phone number for you to call. Don't call until about 4 o'clock tomorrow. They'll give you the date and time to return. It's going to be early next week, all right? That day that you come back, we are picking the jury and we are sequestering the jury. So you're going to need to have packed and brought your suitcase with you to the courthouse. Just leave it in your car. If you don't get picked, obviously you don't need it. If you do, we'll make arrangements for you to pick it up. There's also a sequestration package. It explains about being sequestered. It gives you a suggested list of things to bring with you. There are laundry facilities. You don't need to pack 3 weeks worth of clothing. And lastly, we have a letter for your employer to let them know that you're being called back again. Do you have any questions? Yes, ma'am. It's a lot of information we've thrown at you at one time. If you have any questions, call the jury room, the same number you're calling to find out if you're coming back. Let them know what your question is and I'll answer it for you, okay? All right, thank you so much. Have a good day. All right, we're moving on to panel 10. All right, hold on. I'll be with you in just a second, sir. Okay, thanks. All right. Are you juror 693? All right, this is seat 5, panel 3. All right, good morning. I'm going to have some questions for you. Then the attorneys are going to have some questions for you. There aren't any right or wrong answers to these questions. We're asking you the questions so that we can all, including you, determine whether or not you can do your job as a juror in this type of case. So the only correct answer to any question is the truth. You with me? All right. Have you heard anything about this case prior to coming in here? No? And you're going to need to speak up a little bit because you don't have a mic, so I need to be able to hear you. Okay. Secondly, do you have any position on the death penalty? Yes, sir. Okay. So do you have any beliefs that would prevent you from in voting to impose a death sentence regardless of what the evidence or the law or the facts were? No. On the flip side of that, as I told you, in order to even get to a discussion of whether or not death is an appropriate sentence, someone has to be convicted of first-degree murder, intentionally killing another person. You don't have any legal reason to do it. It's not self-defense. It's not anything. You just killed somebody. And the jury has to make that finding of guilt beyond a reasonable doubt. So now there's a penalty phase. Before a penalty phase ever started, if you convicted someone of first-degree murder, would you automatically vote for death? All right. If I add to that question the fact that the person who died was a law enforcement officer, would that change your answer? And if I add to that question the fact that there was a prior conviction for the murder of a pregnant woman, would that change your answer? All right. everything you answered is the law in the state of Florida. I mean, there are no automatic death penalties. You have to, like I told you, you have to be willing to listen to the aggravators, the mitigators, weigh them, and listening to them means really listen. You need to process this and accept it. In the end, you may decide one or the other side hasn't persuaded you, but you have to at least listen to it. Do you have any concerns about, if you convicted someone of first-degree murder, being able to listen to the very end of the penalty phase, to all the aggravators, all the mitigators? Okay. And as I told you, you have to weigh these out, decide which ones are important to you or not. If, after you did all of that, you felt the appropriate penalty was life without parole, could you vote for that? And if you felt the appropriate penalty was death, could you vote for that? The insanity defense. As I told you, it's been raised in this case. The defense has the burden of raising it and proving it. It's to clear and convincing evidence, which is a lower standard. Pretend that you're at the end of the guilt phase. You've heard all the state's evidence, you've heard all the defense's evidence, and the defense has convinced you with their evidence that he was insane at the time of the crime. Would you be able to return a verdict of not guilty by reason of insanity? Okay. And then my last question is, as I told you, the conviction for the murder of Ms. Dixon and her unborn child, you can't use that to decide whether he's guilty or not of these charges. It's a completely separate case. It can be used in the penalty phase, but not in guilt. Can you follow that instruction? Do you believe you could just put that completely out of your mind when you're trying to determine whether or not Mr. Loyd is guilty of these charges? All right, thank you, sir. I don't have any other questions for you. The attorneys do. Mr. Williams, you may inquire.
Morning, sir. So, given your age and the number of years that you lived in Orange County, did you spend your whole life here? Did you go to high school local? Which high school did you go to? Okay. When the judge, I'm going to start out with the first aspect of the trial and then move through it with my questions. So the first aspect that was addressed with you was not guilty by reason of insanity. And because of that, and that would be a decision you'd make when determining whether or not Mr. Loyd was guilty of the murder, in this case, the alleged murder. Because that is a potential defense, I need to ask you if you or anyone close to you have dealt with or suffered through mental illness. Okay? You don't need to tell me their name, but if you wouldn't mind telling me like their relationship to you and then a little bit about the illness or what you observed. Okay. When you say other mental things, what do you mean? Okay, that's the kind of thing I was looking for, so thank you for that. Because she's typing it down and she can't type down your gestures. I thought I saw you when you said your friend was injured, like reference your head. Did he have a head injury? Were you friends with this person before he fell and hit his head? Did you remain friends with him afterwards? Did you notice a difference in his behavior? There are people in our community that do not believe that mental illness is a real thing. And some of those people take it a step further and say that mental illness is a justification or excuse people use to explain their behavior. I don't take you to be one of those people, but are you? So would you be willing to listen carefully to evidence of Mr. Loyd's mental state at the time of this alleged crime and fairly weigh whether or not he has proven that he was insane and not guilty by reason of insanity at the time of the offense? Okay, thank you. Now I'd like to move to the death penalty aspect of our questions. And the reason I'm going back and forth is because I'm taking notes, okay, so forgive me for walking around. If and only if Mr. Loyd is convicted of first-degree murder, then the jury would listen to additional evidence and render a verdict as to what the potential sentence should be. Did that all make sense when the judge explained it? All right, and I'm not trying to talk down to you, I just know that you've been given a lot of information today, and I want to make sure you're clear and have context for these questions. You said, I believe, that you think the death penalty is possible in a few rare cases. Is that what you said? Okay. So when you made that statement, did you have a specific situation or type of situation in your mind? So when you hear on the news, let's just say you're riding home from work and you hear blah, blah, blah is eligible for the death penalty, blah, blah, blah. What sort of circumstances or what type of murder pops into your mind? Yeah, if you have them, that'd be great. Okay. And I heard you specifically say Jeffrey Dahmer, and then you said something else I couldn't catch. Oh, school shootings. Okay. So you are, I think, describing two what I'll call classifications. You describe gruesome crimes, right? I mean, crimes where there are multiple victims involved. Is there anything about the process, as the judge described it, that you think you would have difficulty going through? So I want to ask a sort of rubber meets the road question. Given that you think the death penalty should be rare, which I think is an accurate statement of Florida law, not hypothetically, but if you're selected as a juror within the next 2 weeks, there is the potential that you'll be asked to listen to evidence, go into the jury room, and vote in a way that would have a significant impact as to what the sentence would be, right? If you believed that we had proven what needed to be proven under the law, and you thought it was the right thing, could you vote to impose a sentence of death on another human being? The aggravators have been proven. Let's say that at least one aggravator was proven beyond a reasonable doubt, and you listened to the evidence of the aggravating factors and the mitigating circumstances, and you reached the conclusion that the aggravating factors outweighed the mitigating circumstances. At that point, you'd be authorized to vote to impose a sentence of death. But it's one thing to do that as an intellectual exercise. It's another thing to look inside yourself and do your best to put yourself in that situation and say, mentally and emotionally, yes, I could do that, given the gravity of the situation.
Objection to witness statement.
Rephrase the question.
Could you, a simple way to put it is, could you vote to impose a sentence of death on another human being if, as I discussed, the law was authorized you to do that?
Objection.
Overrule.
You can answer, sir. Yes, legally, if it was a possibility. Let me back up for a moment because you raised something that's important. You're never required to vote for death, right? I think that's been clear, but I want to say it again. So the law, there's actually instruction that says the law never compels nor requires you to vote. So that's why I keep saying, using these specific words like authorized, and you said possibility, because that's all it could ever be until the jurors, you make an individual decision. It's been called a reasoned moral judgment, right? So you can be given the option, but it's ultimately up to you. And what I want to know is there a universe where you could raise your hand and actually do that if it were authorized?
Can you speak up just a little bit, please?
Okay. I'm going to ask one more different way, then I'm going to leave it alone, okay? Do you have any doubt about your ability to do that?
Objection.
Overruled.
I mean, if the conditions were right?
Objection.
Overruled.
Okay. The last question I have for you, sir, is there anything in your life experiences or background that you think we should know about you, given that we're trying to select the most fair and impartial jury in this case? And I'll give you an example that sometimes I hear when people ask that question. Sometimes people say, well, my loved one or cousin was murdered 5 years ago, and I saw it happen, and I've never been able to get over it, and that presents a problem for me. Anything like that for you? Hopefully not, but anything like that for you that you think we should know? Thank you very much, sir. Thank you, Ron.
You may inquire, Mr. Lenneman.
How you doing, sir? You don't have any doubt that you have in mind that it's all about when you say over the top, it's obviously so knowing that that's the case, follow along.
No more questions? Either side need to approach?
No, you're right.
All right. All right, sir, we're going to send you through to the final round of questioning in this case, and we're going to be picking the jury from that round. If you'll give your badge to the deputy, we're going to change your color to purple. Purple is the final group. I don't know if you remember me telling you that we call jurors in by color, all right? So you're now purple. We're going to give you a packet. That packet has several things in it. It has a slip of paper that tells you what, or that gives you a phone number to call to find out when you're supposed to come back. I don't know the exact date and time, but it's going to be early next week. Call tomorrow after 4, and they'll tell you what date and time. Secondly, in there is a sequestration packet. It tells you what it's like being sequestered as a juror, tells you what to pack, gives you an idea of it. There are laundry services at the hotel, so you don't need to pack 3 weeks worth of clothing. And lastly, there's a letter for your employer in there telling them that you're being called back again for jury duty. If you're picked for the jury when you come back next week, you're being sequestered that day. So you need to come with your suitcase packed and ready to go. You can leave it in your car. If you get picked, we'll make arrangements for you to pick it up. Any questions? All right, thank you, sir. You're free to go. Give me 1 second. Okay, thanks. Yeah. Thanks. This is 10. 10. Okay. Next up is juror in seat number 6, 912. All right. Ma'am, can you stand and raise your right hand? We need to swear you in. You were a little bit late, so we didn't get you sworn in.
You solemnly swear or affirm that you will answer truthfully all questions asked of you as potential jurors of the God?
All right, have a seat. I like your T-shirt. Good afternoon. It's almost noon. We're going to be asking you some questions. I'm going to start, then the lawyers will have a chance. There's no magical answers to these. There's no right or wrong answers. The reason we're asking you the questions is so all of us, including you, can determine whether or not you could do your job as a juror in this type of a case. So the only correct answer to a question is the truth, okay? So let me start by confirming that you've never heard anything about this case prior to coming to court, correct? All right. Do you have any beliefs or position about the death penalty? Okay. Is it something you've ever thought about? You ever been sitting around with your friends and had a conversation about it? Or had a conversation in a class in school? In history? Okay. And in that conversation, did you all have to take a position on the death penalty? Okay. So, do you have any particular feelings one way or another about the death penalty? You can loosen that thing up if you need to. I know, they're horrible. They're just awful. I apologize again. Sorry. We really didn't go out of our way to pick them, but sorry. Go ahead. Well, that is Florida law. I mean, there is no automatic death penalty in this state. It doesn't matter what the crime charged is. We just don't have it. In fact, the automatic penalty for first-degree murder is life without parole. The only time the death penalty becomes a possibility is if the state can prove aggravators, right, that takes the crime to a different area. So let me ask you this. In order to even discuss the death penalty, a jury has to have convicted someone of first-degree murder, intentionally killing another person and having no legal reason to do so. It's not self-defense. There's just no reason. You just did it. And that finding of a jury of guilt has to be beyond a reasonable doubt. So the jury's convinced of this person's guilt. Now you're in a penalty phase, or you're getting ready to start a penalty phase. So my question for you is this. You haven't heard any aggravators or mitigators. You haven't heard the penalty phase. Is the fact that you convicted someone of first-degree murder enough for you to automatically vote for death? Okay. All right, so let me add a fact to that question. The person that died was a law enforcement officer. Does that change your answer? All right. So let me add one more fact, which is that this person was convicted previously of murdering a pregnant woman. Would that change your answer? And the question is, would you automatically vote for death without hearing anything else? Okay. Would that make a difference if they knew she was pregnant? No? Okay. Your answers actually follow Florida law, which is, as I told you, there's no automatic death sentence. You have to listen to the penalty phase. You have to listen to the aggravators, listen to the mitigators with an open mind. You can't sit there with your arms crossed saying, yeah, let's just get to the vote. That's not how this works. You have to absorb all that information and really think about it. Do you think you could do that in this case? And then, once you've weighed those aggravators and mitigators, I've given you all the jury instructions. If you believe the appropriate sentence was life, could you vote for that? Sorry. If you believe the appropriate sentence was death, could you vote for that? Is that a yes? Okay. Let me switch gears on you. The insanity defense. As I told you, it's been raised. It's the defense's burden to raise it and prove it by clear and convincing evidence, lower standard than reasonable doubt. Pretend you're at the end of the guilt phase, all right? The state's put on all their evidence, the defense has put on all their evidence, and you're convinced he was insane at the time. Would you be able to return a verdict of not guilty by reason of insanity? Well, insanity is a defense to the crimes charged, all right? And if someone is insane at the time they commit an offense, they're not guilty of the offense because it's a defense, but it has to be proven by them. So, and I told you, you're just pretending, all right? So you're pretending that it's the end of the case, you've heard everything, and you think he was insane. Could you return a verdict of not guilty by reason of insanity, or would you not be able to do that for whatever reason? Okay. And then last question, remember I told you that the murder of Miss Dixon and her unborn child cannot be used to determine whether he's guilty of these charges or not. Can you follow that instruction? Can you put it out of your mind in the guilt phase? You can use it in penalty, but not in guilt. All right, thank you. I don't have any other questions for you. I'm going to turn this over to the lawyers. Mr. Williams.
Thank you, Your Honor. Good morning. Oh, it's afternoon. It's 12:02. The judge has already asked you about a potential offense of not guilty by reason of insanity. Because that's an issue, I need to ask you some questions that you already sort of answered back on Friday. Last Friday is when you were here, is that right? Whenever it was that you were here. And you told us, I believe, that you were diagnosed with a mental illness, and you don't have to repeat what it is. Okay. Did you tell us you received treatment for that or take medication? You did. Okay. You seem as comfortable as you can be in this setting today. The reason I ask is because I remember you telling us, and if I'm wrong, correct me, last week that you were feeling a lot of anxiety about sitting and being a part of the jury. Right. Have you resolved that issue in your own mind since we last spoke? Well, right. All right, so am I hearing you say that you're concerned that this experience might trigger that? Okay. And I think you previously said that you, on last Friday, that you had never experienced that before. By that I mean being away from your family and not being able to be with them. Okay.
Is that working?
Yeah, come on up, folks. All right, ma'am. I can't tell you how much we appreciate you making the effort to try and serve as a juror and to come in and cooperate with us, but I don't think it's worth the risk to you if it triggers your PTSD. So hope life goes better for you. You're free to go. Thanks. All right, so up next is going to be juror in seat number 9, followed by the juror in seat 14. Good afternoon, how are you? All right, you're juror 534, right? Okay. All right, we have a few questions for you. There's no right or wrong answers to these questions. You're being asked them to see if we can determine, and you can determine whether you can do your job as a juror in this type of case. So the only correct answer to a question is the truth. Let me start by confirming that you've never heard anything about this case. Is that correct? All right. And do you have a position on the death penalty? Okay. To sit as a juror in these types of cases, as I said, you have to be able to fairly and openly consider both sentences, life without the possibility of parole or death. You never have to vote for death, but you have to actually consider it. You have to be, open to it. Do you believe that you would be able to fairly consider both sentences, life without parole or death? All right. So let me ask you some specific questions. As I told you, first-degree murder is the intentional killing of another person having no legal reason to do so. You just killed someone. A jury has to find that person guilty beyond a reasonable doubt. I mean, the jury's convinced they're guilty before you ever get to the possibility of a death sentence. So would the mere conviction of someone for first-degree murder, would that be a case where you would be thinking, if I've convicted them of this, death is the appropriate penalty, having heard nothing else? No mitigators or aggravators or anything? Okay. Secondly, if I added the fact that the person who died was a police officer, would that change your answer? And if I added the fact that there's a prior conviction for murdering a pregnant woman, would that change your answer? Okay. So let me explore that a little bit further. In order to sit as a juror in this type of a case, you have to be able to listen to the aggravation and the mitigation with an open mind, not thinking, I'm just waiting so I can vote for what I was going to vote for anyway. You have to be able to process the information, listen to it, and really think about it, and weigh out life versus death, weigh out those aggravators and mitigators. The prior conviction for murder can certainly be considered as an aggravator. And you can give it whatever weight you choose. But the question for you becomes, is that the point at which you stop listening? Or can you listen to the mitigation and consider it, give it meaningful consideration and say, okay, these things exist, but then on this side are all these mitigators that I want to think about and weigh out before I come to a decision. Could you go through that process in this case? All right. And if that process led you to believe that the appropriate sentence was life without the possibility of parole, could you vote for that? And if it led you to believe that death was the appropriate sentence, could you vote for that? The insanity defense, as I told you, Mr. Loyd has raised that. It's the defense's job to raise it and prove it by clear and convincing evidence, lower standard than reasonable doubt. Pretend it's the end of the guilt phase, and you've heard all the state's evidence, all the defense evidence, and you're convinced he was insane at the time this occurred. Would you be able to vote not guilty by reason of insanity? And lastly, the murder of Miss Dixon and her unborn child. Can't use that to decide whether or not he's guilty. Can you put that out of your mind when you're trying to make a decision as to whether these charges have been proven? Okay. Thank you, sir. I don't have any other questions. I'm sure the attorneys do. Mr. Williams, you may inquire.
Thank you, Your Honor. Good afternoon, sir. Given that the issue of insanity has been raised, I need to ask you a more personal question than I normally would, and that question is, have you or anyone close to you dealt with or suffered through mental illness? Okay. May I ask how long ago she was diagnosed? It's not a new diagnosis. She received treatment or medication? Have you ever had the opportunity to see her when she was?
No.
She's remained pretty compliant. And I'm sorry, I have to ask. I think you can appreciate why. So, given that specific experience, I would think that you understand mental illness is a real thing in our society and have a major impact on people. Would you agree with that? I'm asking because there are people in our community who think that mental illness is not real, and more specifically, view mental illness or claims of mental illness as justifications or excuses for behavior. Do you agree with that? I'm assuming you don't agree with that statement? Or can you tell, maybe, let me be more neutral. Can you tell me how you feel about that statement? Okay. Can you, therefore, listen to any evidence of Mr. Loyd's mental state at the time of this alleged offense, and if it's proven to you that he was insane at the time of the offense, find him not guilty by reason of insanity? Could you do that? The quote that I wrote down for you on the issue of the death penalty was, I don't like it, but I understand it. My first question is, what is it about it that you don't like? Okay? What else? Or is there anything else? There may have been in the past. I don't believe there are anymore. But so the other concern would, it sounds like, might be the arbitrary nature of it. Okay? That's two things. Anything else? All right. The second part of your response was you understand it. Tell me what it is about it that you understand, and I took your response to mean it was sort of, you understand its existence and why we have it. So tell me about that response, please. Okay, it does. Obviously, it's the law in Florida that in certain circumstances it's appropriate, which is kind of what you described. So my question is, do you have any issues with the process as it's been described to you that you will be asked to use? Does it sound fair to you? Okay. If Mr. Loyd were convicted of first-degree murder, if and only if, meaning that his defense of insanity had been rejected, because that's what would be required to convict him of murder, then we would present evidence of aggravating factors, like the judge said. And she alluded to the idea that one of those aggravating factors could be that Mr. Loyd had been previously convicted of murdering a pregnant female. And when she asked you if you could, how that would impact you, you sort of had a hesitation there. Can you tell me about that? All right. Okay. And as the judge described, you could consider that if it were proven beyond a reasonable doubt when it came to the sentence that you would recommend be imposed. You're allowed to consider it, is what I'm telling you. Yes, sir. But it can't be automatically you would vote to impose a sentence of death because you heard that. I don't hear you saying that. Okay. All right. Regardless of what you found or believed about what the aggravating factors were proven and how much weight you give them or were willing to give them, you would still need to be able to listen to the mitigating circumstances, those facts about Mr. Loyd's background, life, and experiences that would be presented to you as reasons why life in prison without the possibility of parole would be justified. You don't have to agree with them, but you do have to consider them, just like the aggravating factors. You may not agree with the aggravating factors, but you have to be willing to consider them. Could you give meaningful consideration to every mitigating factor that was proven to you if asked to do that? And is there anything in your life or background of experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury for this case, which you have now heard involves the alleged murder of a law enforcement officer where the state is seeking the death penalty? So you've already given me an example because you mentioned your two children and you talked about how that impacted your thinking. Anything else like that that we have not discussed? Okay. Okay, I appreciate you telling us that. 20 years ago, I'm sure you're a different person than you were then. But I have to ask, is there anything about that experience, and particularly the way you were treated by law enforcement or by the criminal justice system, that left a bad taste in your mouth? Okay. That's all I have. Thank you very much. Thank you, sir.
Mr. Lenneman, you may inquire.
Good afternoon, sir. How are you? I think the last time there was some possibility of child issues with both people. Would it be something that weighs in your mind while this
Yes. Sure.
So obviously, sir, we want to make sure that this issue is not going to certainly understand that you have exceptional nuance. But on the other side, you're telling me that it's waiting. And so I know that no one can care. Sometimes where you're at. Now, we're talking about, I think the judge asked me before, we are always concerned with this, really fighting person, really shutting down their minds. In your case, you indicated one of the ways a little bit that you understand that. Right. You said you were going to go automatic, definitely. But you had me the outcome in the first part of the process. Okay. And as a lawyer, it's a really difficult responsibility this, you know, with the client's consideration. Now, the way it works is, the way it works in terms of, anytime you get sentenced to the class, and if so there's a big difference in terms of collective versus individual. In the second case, the law is absolutely clear. If you have the individual make all the decisions about that, okay? The only time that you collectively get the relation that you are required, each juror is required to find one aggravating factor in the evaluation. Okay? Required in the end. So that's the only time you do something like this. So from that point on, it's all about you. And what happens next is that you have to consider whether they include aggravating factors. You keep it up. You find weight. You want to look at those aggravating factors. If you do the mitigating factors, by lesser value, and you weight those mitigating factors, then you would weigh them. If your weight comes to the minimum for the aggravation, then it's on that basis. If you believe that aggravation is heavier than the mitigation, then you may go to that. Not required. The law says you never be required to justify. Even if the aggravation is on the mitigation, you have whatever reason it is, you will think can be spoken. You can make that decision. We'll go back to that. And once you make your individual decision, all of those are fine. And for death to be incorporated a sentence, all jurors have to vote for that. If one juror votes for life, out of the 12, that is automatic by sentence. 1, 2, 3, 4, you understand that? Now, at some point, you're going to be back there with jurors. And in the second part of the case, you can talk about things with each other. You don't have to talk about things. But remember, other than that first part of this case, everything is individual to you. So essentially, you can listen to everyone, but everything has to be designed and figured out by you. Once that first part is taken care of, it comes to the ultimate conclusion. So at that point, you're going to be in the jury room with other people. Sometimes things get, because of the consequences and because of the situation that you're heard, sometimes there are people who are extreme. And we'll try to pull it. Now, if you come to the conclusion yourself, under the law, that you need to, I can appropriate sentence, look at it, whatever it is, are you going to allow someone else to do that? Thank you.
Either side need to approach?
No, Your Honor.
No.
All right. Okay, sir, we're going to send you through.
Hold on a second. Hold on a second.
I'm going to take a quick break right after this. Yep. All right, sir, thank you very much. We appreciate your service. You're free to go. You're excused. All right, we're going to take a 5-minute. I lose the court report? No, okay. She'll be back in a second. It's like 5 degrees in this courtroom. Yeah. That's ridiculous. All right, we need to get started. We're back on the record on State versus Loyd. He's present with his attorney. State Attorney's Office is present. Let's bring the next juror in, please. Juror in seat 14. 14? Yeah. 15 and 16 had contact. I'm sorry, what were you saying? Oh, okay. Okay. All right. Good afternoon, sir. How are you? I'm doing well, thanks. We're trying to roll through this. Sorry it's taking so long, but I don't want to bring you back, so. You're juror number 958, is that correct? Yes. All righty. So you didn't indicate to me that I have any notes that you have any prior knowledge about this case, is that correct? All right. Do you have an opinion about the death penalty? Do you have an opinion about the death penalty? Okay. So let me ask you some specific questions. Can you understand me with this mask? Here, let me do this. Oh, I'm sorry. That's right. It's easier for you if you can read people's lips. All right. Sorry. Sometimes my handwriting is so bad I can't read it. So. Let me ask you some specific questions. As I told you, the death penalty in the state of Florida is not automatic for anything. And in order for it to even be a possibility, you must have been convicted of first-degree murder. So first-degree murder, intentionally killing another person with no legal reason for it. It wasn't self-defense. It wasn't anything. You just killed someone. The jury has to make that finding beyond a reasonable doubt. So the jury is convinced of that person's guilt. Are you someone who just the fact that you've convicted someone of first-degree murder would lead you to vote for death? If I added to that question the fact that the person who died was a law enforcement officer, a police officer, would that change your answer? Okay. And if I added to that fact of the conviction of first-degree murder that there was a prior conviction for the death of a pregnant woman, for the murder of a pregnant woman, would that change your answer? Okay, that is Florida law. All right, you heard me describe the penalty phase. State puts on aggravators, defense puts on mitigators. Can you listen to all of that with an open mind, actively processing the information that you're being given and absorbing it? And if after weighing the aggravators, the mitigators, thinking about everything you've heard in the case, you believed the appropriate sentence was life without parole, could you vote for that? All right. And if you believed the appropriate sentence was death, could you vote for that? All right. Let me switch to the insanity defense. As I said, it's been raised in this case. The defense has to prove it by clear and convincing evidence. It's a lower standard than beyond a reasonable doubt. Pretend it's the end of the guilt phase. You've heard all the state's evidence. You've heard all the defense evidence. You are convinced by the defense's evidence that he was insane at the time. Would you be able to return a verdict of not guilty by reason of insanity? And then last question, the murder of Miss Dixon and her unborn child. You cannot use that to determine whether or not Mr. Loyd is guilty of these charges. It can be used in the penalty phase, but not in guilt. Can you follow that instruction? Can you put it out of your mind completely in guilt? All right, thank you, sir. I don't have any other questions. Mr. Williams, you may inquire.
Thank you, Your Honor. May I remove this?
Yes, you may. Attorneys may remove their masks.
To make it easier for you? Yeah, no problem. So your juror questionnaire that you filled out last week indicates that you've been a juror on a prior occasion. How long ago was that, sir? So in my mind, that's pretty recent, despite how long the last year and a half has been. Can you tell me if that was criminal or civil in nature? And so what was the charge or the allegation in the case? That was my question. All right. Without telling me what the outcome or verdict was, did you all reach a verdict? And were you the foreperson of the jury? I came back here because as short as I am, I still can't reach down and take notes on that table. So, okay, good deal. How was your experience as a juror? Can you describe it for me? Tell me what you thought about it? Okay. Given your prior experience and then adding in all the things you have going in your life right now, can you tell me how you feel about being a potential juror in this case, on a scale of 1 to 10, with 1 being you want no part of it whatsoever, and 10 being this would be one of the most exciting things in your life? Okay. My math indicates that 8 is higher than 5, and 5 would be the middle. So what is it about the experience or nature of the case or whatever that puts you at 8 as opposed to the middle? Okay, and that's helpful, so I appreciate it. You also told, let me start with the insanity defense. Because that's a potential issue, and it would involve whether or not Mr. Loyd is guilty of first-degree murder, I need to ask you if you or anyone close to you has suffered mental illness. There are those in our community who believe that mental illness is not a real thing, and more specifically that it is just something that people use to justify actions. Do you agree or disagree with that statement? Okay. What are you referring to when you say you have a psych background? Okay. Took classes, was it like, did it rise to the level like you minored in it, or was it just, it was a major? Okay. So given, understanding you're not an expert, but given your experience with the topic, contact with the topic at least, do you think you could fairly weigh a not guilty by reason of insanity defense? If it were proven to you, find Mr. Loyd not guilty by reason of insanity. Okay. So now we're going to go to the second phase, and I'd like you to imagine that that has become necessary, meaning that Mr. Loyd has been convicted of first-degree murder. And that's when your decision or possible decisions on the sentence of death would become appropriate or relevant. You said to the judge that you believe that there are situations when the death penalty is justified, or if it's justified, then you're okay with it, or something like that? All right, so when you said justified, were you referring to under the law or like in a moral or abstract sense? Okay. So morally, you believe there are situations, if I'm wrong, tell me, but you believe there are situations where a sentence of death might be justified. And hopefully the judge has clarified that regardless of that moral belief, our laws lay out a path for when that is the case. And do you feel you could follow those? Yeah. Okay. As far as aggravation goes and aggravators, the court already told you that a law enforcement officer is the victim in this case. And I think I heard you say that while you would consider that, it would not be an automatic sentence of death for you. Same for the fact that if it were proven beyond a reasonable doubt that Mr. Loyd had a prior murder and that the victim of that case was pregnant at the time, you'd decide how much weight to give it, but you would not automatically vote to impose a sentence of death. Do I understand you right? Yes, sir. Right, and that's a good point because you can't consider it during the guilt phase. But I hear you saying that you could consider it and would not automatically vote for death based upon that fact alone in the second phase. Okay, you're even using the right vernacular, so there we go. Probably the most important part of the whole process is every juror's willingness to give meaningful consideration to all of the evidence they hear. Evidence from us as aggravators, evidence from the defense as to any mitigating circumstances or facts about Mr. Loyd's life, background, and experience. Is there anything that you think you could not consider in Mr. Loyd's life, background, or experience before and give meaningful consideration to when it came to making this ultimate decision?
It boils back down to what is carrying
Regardless of whether you thought it was important, after considering it, could you give meaningful consideration to anything presented? The last question I have, sir, is there anything in your life experience or background that you think we should know about you, given that we're trying to select the most fair and impartial jury in this case where a law enforcement officer was alleged to have been killed and the death penalty is a potential option? You've already given us one example. You volunteered that you had a major in psychology. Anything else like that that you think we should know about in this process? That's all I have.
Thank you, Mr. Rose. Mr. Lenneman, you may inquire.
How are you doing, sir? Good. How much or what percentage do you rely on?
very
So if you would say 10% of the information that you cast would come from the now you had said, I think the quote was justifiable at the end of the day. And there's certain complications in the
that's the kind of offense you're thinking about. Now, what was your plan, goal, when you were choosing psychology? What were you planning to do?
Well, one is, honestly, I was looking for it.
So you weren't really looking into social work, therapy, is there a preference that you from your perspective? Now, when we talk about the death penalty, we talk obviously about aggravators and get away each of those sometimes. I don't talk about mitigation. Do you agree with this? Would you be able to get basically the effective basis on someone's life, consideration, we're not talking about what it is. We're talking about the effect. Mitigating factors. Some people say no, consider it. Say no. So if you had, you were presented with the mitigating factor, and this would be high, would you be able to make that decision? Tell me how that is different from what you said.
Well,
Well, before you said, how the skin doesn't matter. The ability to consider what you initially said changes the
Objection, ask and answer.
Sustained.
when we feel the mental health consideration. So the issue really is not whether you can or cannot. The issue is whether it presented to you at time.
Objection.
Sustained. Rephrase, Mr. Lyman.
You're saying what is presented. I offered anything. Anything. Would you be able to consider whatever way you want to consider it. Using factors. the mental health actually impacts the you think
Let me intervene here for a moment, just for clarification points, then you can get back to your question, Mr. Linneman. Let me clarify for you what mitigation is, okay? Mitigation is evidence that is offered after there's been a conviction for first-degree murder, which is premeditated intentional killing of another person. You're done with that part, okay? Mitigation is offered as to someone's background, their character. It can be offered as to the circumstances of the offense, but it's not limited to the circumstances of the offense. And mitigation is offered as reasons for you to consider that that the more appropriate sentence for them would be life without the possibility of parole rather than death. Do you follow me? Right. Guilt is done. Mitigation has nothing to do with guilt, all right? Mitigation has to do, the person's been found guilty. Mitigation has to do solely with the sentence that is appropriate. And therefore, mitigation can be almost anything. I mean, there are limits, but it can be almost anything. And so you're offered evidence of someone's background and how it affected them. You're offered evidence of the person's character or the circumstances surrounding the offense that may not have come out in the guilt phase. Are you following me? Okay, you clear on what mitigation is?
Yeah.
All right, Mr. Linneman, you may re-ask your question.
so if you were presented
I know you said that you believe this, but do you think you can have an example? No, this, and this is.
Objection.
Sustain. Sure.
there may be times when we get into a situation where someone doesn't agree with you with your decisions. If you have a firm decision, no matter what it is, would you stick to it and not allow someone to change it?
I would want to say, keeping my view, but I still feel it's right. And there's no discussion about how the service built it. Still, I firmly stand where I am. I think that's what I would
Okay. Well, let's say you have a firm condition that you not want to keep. Under the circumstances, you throw it in there after the jury talk about things, you have a firm condition, you're not going to keep it. What is the important
Objection.
Objection, or I'm sorry, objection sustained. Go ahead.
You understand that unlike when you were a juror, which is like the first stage of this case, there's a difference in penalty, which is you won't talk. And are you going to try to force someone?
Thank you.
1 second.
Any additional need to approach?
No,
No?
Your Honor.
Sir, remind me which ear you're deaf in. Is it the right one? Your left ear. Okay. Oh, yes, it does. All right. All right, sir. We're going to send you through to the final round of questioning. The next time you come, we're going to pick the jury from that group. So, a couple of things are going to happen. If you'll hand your badge to the deputy, you are now a purple dot. We're going to give you a packet that has some information in it. It has a slip of paper that has a phone number on it. Call tomorrow after 4. You're listening for them to tell you when the purple group or the purple dots are to return. It's going to be early next week. I don't know the exact date yet, but I should know it soon, all right? The day you come back, we are choosing the jury and we are sequestering the jury. So you need to pack a suitcase. Leave it in your car. If you get picked, we'll make arrangements for you to get it, all right? There's also a sequestration packet in there that explains being sequestered to you. It gives you a list of things we think you should pack and some, just explains the process to you. There is laundry available, so you don't worry about packing for 3 weeks. There are laundry facilities. And lastly, there's a letter in there for your employer telling them that you're returning one more time. Do you have any questions? All right, I'll see you next week. Thank you. Juror in seat 15. I count only 15 and 34 left. Okay, thanks. Good afternoon, ma'am. Hi, I'm sorry this took so long, but I don't want to bring everybody back, so we just plowed on through. This is a serious case. We have to take our time. I'm going to be asking you some questions, and then the lawyers are. There aren't any right or wrong answers to these questions. They're just designed for you and everybody else to figure out whether you can do your job in this case, all right, as a juror. The only correct answer is the truth. So let me start with, you said you had heard something about this case? Okay. So all you remember is a woman police officer and pregnancy? All right. Is there anything about what you heard that caused you to form an opinion as to whether or not Mr. Loyd is guilty? Can you presume him to be innocent until and if the state can prove he's guilty? All right. The death penalty. Do you have any particular position on the death penalty? Okay. Mr. Bundy jumps to mind for a lot of people when you talk about the death penalty. So let me ask you a few more specific questions. In order to even have a discussion about whether life or death is the appropriate sentence, you have to have convicted someone of first-degree murder. First-degree murder is the premeditated killing of another person with intentionally killing someone with no justification. It's not self-defense. You have no reason for doing this. You just did it. Okay, you follow me? You have to have found them guilty beyond a reasonable doubt, meaning the jury's convinced of their guilt. Is that fact alone, with nothing else, if that was all that you had, you've convicted someone of first-degree murder, would you automatically vote for death? If I added to that that the person that was killed was a law enforcement officer, would your answer change? And if I added to that that there is a prior conviction for the murder of a pregnant woman, would your answer change? Okay. In order to, and you're correct, there is no automatic death penalty in the state of Florida. It just doesn't exist. So in order to sit as a juror in this case, you have to be able to listen to the penalty phase, the aggravators and the mitigators. You have to be open to it. You can't sit there with a closed mind towards one side or the other. You have to listen to everything that's presented, process all that information. Can you do that with an open mind? You then have to weigh the aggravators and the mitigators, follow the laws I've directed you, but weigh those aggravators and mitigators. And finally, if all of that led you to believe that the appropriate sentence was life without parole, could you vote for that? Yes, ma'am. And if you believed the appropriate sentence was death, could you vote for that? Let me switch gears to the insanity defense. It's been raised in this case. Defense has to prove it by clear and convincing evidence, slightly lower standard than reasonable doubt. Okay, it's a lower standard. Pretend it's the end of the guilt phase. You've heard all the state's evidence. You've heard the defense's evidence. They've convinced you he was insane at the time of the offense. Would you be able to return a verdict of not guilty by reason of insanity? You've gone through the guilt phase where you're trying to decide whether he's guilty or not. Insanity is a defense to the charges. It would mean the defense of insanity, if it's proven, is a not guilty by reason of insanity verdict. Some people can't do it. They just say, no, I'm never going to find somebody not guilty by reason of insanity. So the question I'm asking you is, if you were convinced by the evidence that he was insane, could you reach a verdict of not guilty by reason of insanity? Okay, what would cause you to hesitate? Okay. Yes.
Should I elaborate?
Yes. It's freezing in here, isn't it? It's about 10 degrees, yeah. Okay. Okay. Okay, thank you. Let me see the attorneys at the bench. All right, ma'am. I'm going to excuse you as a juror in this case. We appreciate your time and your honesty. You have a good day. I hope you warm up quickly. It's freezing in here. All right. And lastly, we have juror in seat number 34. This is juror 738, correct? All right. Sorry to keep you waiting, but you didn't have to come back later. I have a few questions for you. There aren't any wrong or right answers to these questions. The questions are meant to determine whether or not you can do your job as a juror in this case. So the only correct answer is the truth. Follow me? All right, let's start with, do you know anything or have you heard anything about this case before you came to court? All right. Do you have any opinions on the death penalty? You don't support it? Okay, so is that a personal, religious, or moral opinion, or all of them? Okay, how long have you had that opinion? Okay, you're gonna have to speak up just a little bit. What? Okay. So in order to sit as a juror in this case, I mean, Florida law never requires a death penalty, but you do have to be able to fairly consider it. Not consider it, and then I'm going to vote for life, no matter what I hear. It's consider it, think about it, and if you believe it to be the appropriate sentence, vote for a death sentence. Can you do that, or are your beliefs such that regardless of what you heard, you're always going to vote for life without parole? All right, thank you, ma'am. Either side wish to inquire? No. Mr. Linneman? All right, Mr. Linneman? No. All right, thank you, ma'am. You're excused. Have a good afternoon. All right, we have 55. I can call a small panel in tomorrow morning and see if we can get 5 more and then do the the motions in the afternoon. Input? I rarely ask for it. Take advantage, Mr. Williams.
I almost said that, Judge, but I didn't. So good for you.
It's all right. I said it for you.
Yeah,
Go ahead.
That sounds like a splendid plan to us.
All right. Defense? We're good on calling a small panel in. All right, so based on the percentages, and we need about 5 more people, tell the jury room I'm gonna need 40 jurors tomorrow morning in this courtroom. We can fit 40 in here, no worries. 9 a.m., I'm gonna do both hardship and individual until I get to 60, or until I get to a number that's reasonably close to 60. General voir dire, Monday morning, 9 a.m. Your motions will be heard tomorrow afternoon beginning at 1:30. Anything else?
That would be in here?
In here, yes. I'm only going back to 23 if I have to. I like this courtroom. I've made arrangements to be in this courtroom and to try the case in this courtroom, absent being told that there's a security problem of any kind, because everyone can hear everything in this courtroom. So, yes. Although I may have to go back to 23 because of the size of the panel. I just need them to call, I need 40 jurors tomorrow. Call off everyone else. Oh my God. But all of tomorrow is in here. I'll take it from there. We actually can't fit 60 jurors in here. Just remember that. For tomorrow, we'll just be in here. I'll work the rest of it out. Yes?
That's what she.
No, I want them in here tomorrow. Any other questions? You may. Come on up. Court's in recess till 9 o'clock tomorrow morning.